All right, folks, welcome to GAMcast Live, the biggest story of the day. The biggest story of the day, October 31st, 2022, Halloween, otherwise known as Halloween. Happy Halloween to everybody. Is that the left, in the arguments over affirmative action in the Supreme Court oral argument this morning, argued that the Constitution isn't colorblind. Now, folks, this is a big story, a huge bombshell story, actually. Probably not hearing a lot about it elsewhere. So, again, we try to keep these under 4 minutes. Welcome to GAMcast Live, the GAMcast of Florida and Georgia lawyer that breaks down the news of the day through the lens of the Constitution, the law, and history. You really need all three to follow this issue. Folks, affirmative action was first said to be constitutional in the Bakke versus University of California decision in 1978. It was a white medical student who did not get into the medical school, University of California. I think it was Berkeley, but it doesn't matter. It was the California system. And he was able to show that, but for the fact that they had to choose a black person, he would have gotten in. And the court said, well, that does violate your constitutional right. The 14th Amendment says the Constitution has to be colorblind. The Constitution has to be colorblind. But we're going to allow the Supreme Court or the state to do it in this instance to make up for past discrimination. And the question then was, well, it is discriminatory, it is against the Constitution, but to make up for past discrimination, we're going to allow it. And the question then became, how long? Well, it came up again in the 90s, and they said, well, we're still not there yet. We need to let it go a little bit longer. Here it is now, 2022 again. A lot of the argument this morning concerned, well, we there yet? Unfortunately for us, the Democrats and the left have changed their tune. Larry Tribe, who basically taught a lot of these people that are on the Supreme Court, and I'm not kidding, he's a Harvard lawyer, he's a professor out there, wrote one of the constitutional law books out there. This morning, listen for echoes of Chief Justice Roberts' too clever line, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. If that empty truism haunts the Halloween proceeding, expect a big loss for racial integration. The left now believes it is absolutely proper to discriminate based on race, and that was the intent of the people that passed the 14th Amendment in 1865. Of course, that is absurd. That has never been suggested until recently. Take a listen to the government arguing before the court defending that ridiculous position.
On both sides, there's been very little discussion of what originalism suggests about this question. So I just want to ask, what would a committed originalist think about the kind of race consciousness that's at issue here?
I think that an originalist would think that this is clearly consistent with the original understanding of the 14th Amendment. The universities have come forward with powerful evidence that surrounding the time of enactment of the 14th Amendment, there were...
Notice she doesn't mention any
federal and state laws that took race into account for purposes of trying to achieve the central premise of the 14th Amendment to bring African American citizens to a point of equality in our society.
Folks, if you believe in 1865, the Republican Party that was responsible for all this, believed that the government was going to make people equal, I don't know what to tell you. And that's what she just said. Oh, come on. Don't give us technical difficulties. I hate when it does this. Come on.
There's been very little discussion of what...
Now it's not going to let me fast forward it back to where we were. All right.
Into account for purposes of trying to achieve the central premise of the 14th Amendment to bring African American citizens to a point of equality in our society. And I think what's so notable, if the court is focused on history here, is that petitioner has come forward with essentially no history to support this colorblind interpretation of the Constitution that would make all racial classifications automatically unconstitutional. There's nothing in history to support.
All right. The reason they haven't is that no one's ever suggested anything other than that ever, and it's obvious. Anyway, we try to keep these under 4 minutes. Huge story. You're not going to hear about it in the mainstream media. The left and the Democrats on the court and before the court all basically now think it's okay to discriminate as long as you're doing it in favor of blacks and persons of color and against whites and Asians. Anyway, try to keep these under 4 minutes. If you enjoyed this, please like it, share it with friends, subscribe, and if you enjoyed this, I hope you tune back in next time.